It's an act of love to do this for the people that you're leaving behind.
It's not just seeing a lawyer. It's not just what goes on the paper. It's about planning what things will look like once you're gone.
Hello, I'm Nate. This is Matt. This is episode 5. We're covering estate planning. It's called The Art of Dying.
Just a quick disclaimer, the topic of death and dying can be an uncomfortable topic for many people, and ourselves included at sometimes. And everybody deals with discomfort in a different way. For the three of us, we often laugh and we joke. And I just like to say that this is a serious topic, but we cope sometimes with humor. So please
absolutely
bear with us.
And to our left is Amanda Forsey Taylor.
Yes.
Of Evangeline Law.
Mm-hmm. Yeah. You're our first guest, Amanda, ever.
It's an honor.
It's awesome to have you here. I've got an official bio here for you, Amanda. Shall I give it a little read?
Yeah, it looks like it comes straight from the website.
Yeah, I edited a little bit, but nothing.
What did you edit about it?
Nothing. I just shortened it a little bit.
I also edited it a little bit after he did.
So our first guest ever, Amanda Forsey Taylor, was born in Windsor, Nova Scotia, born and raised Windsor, Nova Scotia, right?
Yeah.
And then following the completion of your undergrad studies at St. Mary's University, you went on to, could I say, complete your law degree through University of New Brunswick?
Yeah, at the University of New Brunswick, yeah.
And then you returned to the Halifax area from New Brunswick and articled at a prominent personal injury firm. And then, I guess, spent a number of years developing your knowledge and practice until you joined Evangeline Law with Trevor Hughes in Windsor, Nova Scotia in 2022.
Yeah.
Right.
And when I joined Trevor, he had just been I shouldn't say just, but he had been operating as a sole proprietor without a ton of branding because he always used his law practice as a way to service the Evangeline Wealth Management clients. And after joining him, he said, let's get a little more serious about it. What should we call our law practice? And it just seemed so natural that it be called Evangeline Law. Just because of the close and ongoing relationship that the law practice and Evangeline Wealth Management had, and hopefully will continue to have for many years to come.
Absolutely.
Yeah. So what's missing from this too is the designation that you recently completed.
Oh yeah, very exciting.
Because we're talking about it today, so you might as well say what you studied and have something hanging on your wall in your office on.
Yeah, so I was looking for a little more street cred, so I went and studied. And I wrote my TEP exam, and what TEP stands for is Trust and Estate Practitioner. It's a designation from the Society of Trust and Estate Practitioners. It's designed to show clients that there's this extra level of tax knowledge and corporate planning knowledge that you have as a TEP. So it allows me to have the background and to really assist with more complex estate planning matters.
Nice.
Which may lead to future podcasts.
We are all part of an Evangeline group of companies.
Yeah. Mm-hmm. We're not related and we are related all at the same time.
Yeah. So there's Evangeline Wealth Management. Nate and I are part of Evangeline Wealth Management. Mm-hmm. And then there's Evangeline Law.
Yeah, which is, same in name, but not in ownership.
Right.
Yeah. And then behind the scenes, there's also Evangeline Tax Advisory. But they are all sort of like a part of the Evangeline group of companies charting their way back all to like 1964.
67.
Something like that.
It's the last year the Maple Leafs won a Stanley Cup.
That's how you remember it?
Yeah, that's how I remember it.
I'll hang on to that one.
Yeah. No correlation? I don't know.
Yeah, they really came to be, I think, because it was a group. It's continued to be a group of like-minded people who just are really focused on being client-centered and bringing your clients the best result and best service possible, and having control over that client service. So when you send someone to Evangeline Wealth Management that they're not going to come back to me and say, well, that's not a great fit, because I know you guys and I know the other advisors and we're very like-minded in the way we want to treat people and how we want to do business.
Yeah. And vice versa. Yeah. refer all of my clients to Evangeline Law for estate planning and real estate. There's just no one else that I would consider, really.
So that ties into like why we're doing this podcast.
Well, and I guess the concept or idea behind this episode is that, we know that the foundation of a good financial plan or financial planning relationship is an estate plan. And that estate plan is sort of key to just securing the way forward. But that can be an uncomfortable topic for many people, right? A lot of people know that they need a will, know that they need powers of attorneys in place, know that they need a plan. Mm-hmm. But on the way in, I heard a stat from another podcast, a good podcast, great podcast called Rational Reminder. And someone was referencing a study done way back in 2016, but still relevant, that it was something like 2/3 of Canadians don't have a will. Mm-hmm. And of those that do have a will, it's like 15 to 20% of them are out of date. Right. So a lot of people, this is a big gap that needs filling. Yeah. And so the idea behind this episode was that here's something we can produce that we can send to someone that is kind of mentally preparing to sit down and have this conversation with an estate lawyer.
Yeah. No, that's great.
Yeah.
Because it's an uncomfortable conversation, and we just want to give someone a primer in order to just feel more comfortable with some of the subject matter.
Absolutely.
Yeah, whenever someone expresses, because it happens to me a lot, maybe I have someone in my office for a property transaction or something unrelated to estate planning, and they'll express to me that it's something they need to do, but they often express it with shame. And I say to them, I get it. It's not a fun thing to talk about, and it's not a fun thing to spend money on. So I can see why you don't jump on that at, the age of 20, 30, 40, even older.
Totally. Yeah. Even I was talking to my father about doing this, and my father had to deal with his parents' estates, and there was no planning done for their estates whatsoever. Mm-hmm. And my dad kind of pointed out that it's an act of love to do this for the people that you're leaving behind.
Absolutely.
Because it can make everything a lot easier on them at an already difficult time. So he coined it as, the art of dying, right? He's like, there's a real art in leaving things behind.
Yeah,
absolutely.
In a nice way, because he was emptying out storage lockers and doing things that you don't want to do while you're grieving.
Yeah, and correct me if I'm going too far off topic, but it really is an art in the sense that there's no one answer and there is no one way for everyone. A lot of people oversimplify it, I find, when they come into my office, and then I'll often start asking questions in a way that leads to more topics. It's not just seeing a lawyer. It's not just what goes on the paper. It's about planning for what things will look like once you're gone. It's more fulsome than just a will.
I don't think that could be any more on topic.
Because the three of us are here as professionals, and we help facilitate the conversation to generate options. But it's really about how our clients feel about those options going forward and in the way they implement them.
Absolutely. Maybe a good way to start is to sort of contrast, what happens when someone dies and there's nothing in place.
Yeah.
Like maybe that's a good starting point.
I find that can be a good motivator to buckle down with the estate plan is if I say, if you pass away tomorrow, this is what could happen. I think there's a lot of common misconceptions about what happens to your assets and who can take control when you pass away. Mm-hmm. I can't really give one big answer today for everyone because it really does depend on if you're legally married,
May I paint you a picture?
Yeah, sure. Okay. Give me an example.
Yeah. Okay, so you've got Mr. and Mrs. Jones, right? They've got 2 kids. They've got a dog, both active on social media, big investment accounts. House and a cottage.
You've got a lot going on there.
They got a fair amount.
They got stuff. They got assets. They got liabilities.
Stuff.
Yeah.
The children could be an asset or a liability.
Children are young, right?
Children are under 19.
Under 19. Yeah. So, unfortunately, Mr. and Ms. Smith are avid skydivers and
The
They had a lot of fun up until that fateful day where their chutes didn't open.
The chutes didn't open and they went splat.
Yeah.
At the same time.
Yeah. At the same time. Yeah. Doing what they love.
Okay.
Okay. So if they don't have an estate plan, in that case, their kids would be entitled to their assets.
Okay.
Interestingly enough, if it can't be medically determined who died first, which presumably in
That might be difficult.
parachute accident, they were splatting at the same time.
Fair. Yeah.
Do they go by like initials of their last name or something before their middle initials?
In Nova Scotia specifically, it's assumed that the youngest person lived longer.
Okay.
Interesting.
Yeah. Every province and presumably state has different ways of determining this, but in Nova Scotia specifically, it's assumed the younger person lived longer.
Okay.
Okay.
So anything they held jointly ends up, let's say Mrs. Jones is a little bit younger. You know, she wanted an older man. So it's assumed that she passed second. So that means anything they held jointly would have landed in her estate. Anything that he had a beneficiary designation of her on would have landed in her estate. Presumably they have been married a long time and they set up everything such that it was jointly owned. We'll get into that topic a bit as well today about how you hold assets. Then Mrs. Jones, she has 2 children in this case, and her kids are entitled. Unfortunately, because they did not have a will, the public trustee is who is entitled to, in most cases, take care of that money for those kids. And the office of the public trustee is full of really great people who are presumably very busy. And they don't know you personally. They don't know your kids personally. They're not probably in the best position to make decisions that would be best for your specific children and your family.
Fair.
Yeah, they don't know the wishes. They don't know the presumed plan.
Exactly. All they can operate is within the bounds of the law on that they have to act in your kid's best interest. And that is a subjective. There are objective factors there, but there's also subjective factors.
Yeah. I think one important thing to mention too is I spend too much time waiting around tax stuff is when individuals pass away, their CRA are deemed to have, you sold all your stuff the day before you died. And each thing that has been sold has varying tax consequences as it flows through your estate.
Yeah, as an example, in this case, the cottage, maybe that cottage has been in the family for several generations.
Right.
That now has a deemed disposition.
Warning, financial jargon alert. Deemed disposition means the government pretends you sold something like a house, cottage, or investment even if you didn't actually sell it. And you may have to pay tax as if you did. As an example, let's say you bought a cottage years ago for $100,000 and now it's worth $300,000. If you give it to your child, the government acts like you sold it for $300,000. That $200,000 gain is deemed income and you might have to pay capital gains tax on it, even though you didn't get any money.
There'll be capital gains tax owing on it. Maybe the public trustee says, well, it's not in the best interest to hang on to this cottage property. It's both an asset, but it does have liabilities associated with it. So they sell the family cottage and the kids never get to hang on to it as the next generation. So there are things like that you just lose control over.
Yeah.
What I say to people when they ask, well, is it time for me to get an estate plan? I say, well, do you care to spend money to control what happens in the event you pass away or become incapacitated?
Right.
Because at what point do you?
That's a good way to put it.
Do you care more about the uncertainty than the money that you're going to spend to?
Yeah,
to
that's a helpful kind of weighing tool, right?
Yeah.
Because in this situation, you have a cottage that you may have had wishes for that could possibly just be liquidated out of the family.
Yeah.
You have kids who you may have had guardians in mind for who may end up kind of legally steered somewhere else potentially.
Yeah, to the province or to some sort of,
Yeah, exactly. You just lose control over what happens. And that's the benefit of the estate plan is the control. I know we want to talk a bit about probate as well, because I feel like often people come into my office really concerned about avoiding probate, and they think that probate tax is going to absolutely kill them and their kids will be left with nothing.
Let's pause and explain probate just to the layperson.
Yes.
Yeah.
So probate or administration is a court mandated process that you are required to complete in certain circumstances of your death. It requires that someone apply to be the administrator or executor of your estate, and they have to then advertise in the Royal Gazette for 6 months. They become responsible for filing your final income tax return, paying any debts you owe, and they then ultimately become responsible for distributing your assets according to law. If you have passed with a will, it would be according to the terms of the will. If you pass without a will, it would be according to the terms of the legislation.
Yeah,
right.
And just to add to that as well, like this is it's a public process, right? Yeah, and there's differing rules province by province here in Canada.
Correct. And if you own assets in multiple provinces, you have to probate in multiple provinces.
Okay.
Nova Scotia does have a probate tax. It's not a flat percentage, but it does equal out to be approximately 1.67%. So it's not huge relative to income tax, as a lot of people I'm sure know. But it does cost money, absolutely, and there are legal fees. It's every lawyer is different with how they structure their fees in it, but often relative to the probate tax, the legal fees are not substantial.
Right.
No.
Then I imagine there's some accounting that would need to happen as well, which would carry its own costs.
Yes,
but maybe that happens regardless of probate.
Yes, exactly. Yeah. So whether you have an estate that needs to be probated or not, that final income tax return does need to be filed. And I always recommend that you don't try and DIY that one.
Yeah, fair.
One way I start my conversations with clients is, yes, your will is important, but let's talk first about how you hold your assets, because how you hold your assets determines how they pass when you pass. So regarding any jointly held assets or any registered accounts, which I think registered accounts were defined in one of your earlier episodes.
Yeah,
I believe so.
We did.
Was it the acronym anyone?
Yep, it was. Yeah, so registered accounts being RSPs, TFSAs, RIF accounts.
Yes.
Anything registered with the CRA, essentially.
Yeah. So if there are beneficiaries placed on those accounts, they will pass outside of what is dictated in your will. And similarly, if you hold accounts jointly, they will pass often to the survivor outside of your will with let's put an asterisk on that too. Yeah. So.
Yeah. And as well as various types of like life insurance and insurance investments, they also pass, outside of probate in your will as well. Because you can, name beneficiaries to them.
So for everything else, so to say, or keeping that in mind, there are some key documents that are part of every kind of well-crafted estate plan, right?
Yeah.
And so the will is obviously a centerpiece.
Yeah, and I always define that as the document that dictates who is in charge and where your stuff goes when you pass away. Again, not counting the beneficiary designations and the joint account possibilities. Aside from that, there are two other documents in the province of Nova Scotia. Every province does this a little bit differently. So the power of attorney and the personal directive are two documents that operate while you are alive, but they are extremely key in regards to your estate plan. The power of attorney dictates who is in charge if you ever are unable or unwilling to take care of your financial matters or legal matters. So I always explain it to people as if you ever want to, if you ever are physically unable to pay your bills or direct your lawyer in a certain way, that person is the person who will do that for you and on your behalf.
Yeah. So like as financial advisors, we tend to work with power of attorneys a lot, like as people age and become more elderly. And they find it a little bit harder to think through financial decisions on their own.
Mm-hmm.
Yeah, as you get older, you often become a little more stressed or overwhelmed by the thoughts of what to do. And so it can be really helpful to have someone who can make those decisions for you, especially if it's someone you trust. I always differentiate this greatly from the personal care directive because the power of attorney takes effect as soon as you sign it in most circumstances. At least that's the one that most lawyers will recommend to you, I believe.
Oh, you have a story about that, an example about the power of attorney.
Yeah.
Oh, was it sea captain?
Yeah, the sea captain's.
Okay, go for it.
Fear the sea captain story. So there was this sea captain. He, I believe, was a fisherman. Mm-hmm. He went and did his estate plan. He appointed his wife his attorney under his power of attorney. Mm-hmm. They get in an argument and he goes off to sea. He goes off to work. Comes back a month later. She has sold his house, liquidated his RRSP, and just taken off.
Oops.
So this is because she had a signed original copy of the power of attorney after the estate plan was created.
Yeah. You're not supposed to do that.
Mm-hmm.
Your attorney does have an obligation to act in your best interest, but it didn't stop her from doing it.
Some things are hard to undo once they're done too, right?
Yeah.
Yes.
Like, how do you catch up with her?
Right.
Did she already spend all the money anyway?
Wow.
You can't suck blood from a stone.
No,
So.
It's hard to put a cat back in the bag after you let it out.
Truly. So it is an example of one, you really want to trust your attorney.
Yes.
You really want to trust your attorney. And don't piss off your wife.
My power of attorney is locked in my office and only Matt knows where it is.
That's true. Okay.
Sorry, wife Amanda.
This is an important distinction. I remember sitting in an estate planning meeting with you, and you conveyed to the person that this power of attorney, was essentially active as soon as they walked out the door.
Correct.
Right? They could walk into the bank. They could do many things with this power of attorney.
Yeah. And someone might stop them in their tracks and start asking questions.
Fair.
They might say, hey, why is Margaret not doing her own banking anymore? What happened to Margaret?
Right.
And maybe her attorney, Cindy, gives a really good answer and the bank takes it.
Right. Because
in theory, as soon as you're appointed and you have that document in hand, you can go wild. There are restraints. There are avenues within the law to stop that.
Right. But to your point, if you could get damage could happen potentially before anyone stops anything. Right?
Absolutely.
Yeah. So appointing people for various things is very important.
Yeah, and just to briefly with the personal care directive, it's appointing someone in charge of your medical and personal care decisions if you ever become incapacitated. As long as you're breathing and awake and can make your own choices or can understand the consequences of your actions, you make your own medical and personal care decisions. And that's why it makes sense to have those two documents split. Also, because they're two very different roles. You may trust one of your children with your healthcare decisions and the other one with your financial, and they may not be the same child.
Yeah,
that's
very
fair.
True.
That's fair. So in absence of these things, of course, we end up in a situation potentially where the things that we discussed earlier, like probate, become a lot more involved because just, going back to the topic of doing it yourself, sometimes I've come across, DIY investors that have set up their own accounts and set up their own group RSPs and, they've filled out all the pension paperwork for work. And I'm going through all their documentation and their beneficiary for each account is listed as estate. And yet they're married.
Well, yeah, it goes back to how we started the episode and talking about how different assets have different tax consequences. When you look to like RRSPs or RIFs, like registered retirement income funds, like all those types of things, those have preferential tax treatment with your spouse. So there's a tax-free rollover that can occur if it's filled out correctly. If not, if you name your kids and not your wife, it sometimes can be fixed, but it's technically a deemed disposition, and all that savings within those vehicles sort of counts as taxable income on the day before you die.
Right.
And it tends to make a mess and create a huge tax liability.
Yeah.
Yeah, I actually have one situation that happened more recently where this is a guy who's been married a couple of times.
Mm-hmm.
And his latest wife has dementia, and he really doesn't like his wife's kids. He really, really hates them.
Mm.
So he says, I want my new girlfriend to receive my whole estate. Goes to the lawyer, has it so that his estate is held in trust until his wife passes, and then it goes to his girlfriend. Wife doesn't need much because she has dementia and she's in a home and doesn't have a ton of needs at this point. But the lawyer doesn't ask, who are your beneficiary designations? Do you hold joint assets together? So it has resulted now in girlfriend has next to nothing.
Oh, it all went to the ex-wife who has dementia and is in some sort of care facility.
Yeah, and to top it off, she's also now deceased. So the kids that he hated
are ministering
much richer.
Oh, I guess this ties back in a lot to just that introductory meeting when you're sitting down with like an estate lawyer. Myself and Matt as financial advisors tend to be in introductory meetings, making sure that like assets and liabilities, and we're articulating like that household's sort of goals and objectives correctly, and as well trying to help navigate a little bit of the family dynamic, just to make sure nothing's missed and that we're really thorough.
Yeah.
Yeah, and I should correct that too. Lawyer might have not asked, client might have not told.
Yes, very true.
enough.
Yeah.
This goes back to the Ben Franklin quote: "If you fail to plan, you plan to fail." Right? Seriously. I mean,
That's so deep.
Well, it's one of these things, I guess, that can occur if you make the decision not to do anything, right? And we often tell people, like, doing nothing is also a decision. Right? Yes. Some people feel as though they're avoiding a decision by not making a decision, but
you're making a decision by that.
Yeah, exactly. Which can have consequences. Right? What would you say to someone who asks you, Amanda, ahead of our meeting, what are some of the considerations, or what are the things that I should be thinking about in regards to drafting my will?
You should be considering, you don't need to necessarily know who your executor is that you want or your attorney. Start thinking about the people in your life that you trust, that are important to you, that are organized and can complete tasks efficiently. Also start thinking about what assets you hold. And this includes things like, did my mom put me as joint on her checking account? Or am I on my family cottage, even though we still treat it like it's my parents' cottage, but my name is actually on the title? Start thinking about those assets that you own and who those people are that are important. You don't need to have all the answers when you come in. I'll often send out my intake to people and say, hey, this is what we're working towards, but if you don't fill it out in completion before we meet, that's okay. We'll keep working on it together. But it at least gives you something to think about ahead of the meeting.
Nice. Yeah. And I had something else. Hold on. Let me think about it here for a second. Things to think about when you're coming in. Oh, yeah. You mentioned an important word when it comes to estate planning. I guess it's the title, the executor. Right. So can you talk a little bit about who the executor is in an estate plan, why they're important?
Can you have multiple executors?
Great question. And the executor, we touched on a little earlier. That's the person that's in charge of what happens and in charge of getting tasks done. So they'll hire the lawyer to help administer the estate. They'll go find the tax accountant to file your tax return. They make sure your debts are paid. They'll gather what assets you do have. Maybe you have bank accounts at 5 different banks. Well, then they have to go track those down. Or if you have 10 different credit cards, they have to track those down and make sure they're all paid and closed. They also are in charge, of course, of this is dark, disposing of your body.
Oh, wow. Okay. That's their decision.
Yes. And hopefully
they don't have to dig the hole though.
No, they don't. Okay. And they don't toss you in the incinerator either.
Okay. I'm sorry, child.
I'm sorry, I talk about death too much.
Yeah, fair. Someone's got to do it. Yeah.
But all that sounds like a job.
Yes.
As a result, is there some sort of mechanism where they get paid?
Yes, there can be. So under the legislation, you can ask for up to 5% of the gross value of the estate. There's two ways to get this. The first way is by consent. So all the beneficiaries say, yep, you're right. That was a job. Here's your 5%. And they consent to it. If not all the beneficiaries consent, or if some of them are under the age of 19 and are deemed to not be able to consent, or if there's some other reason they're not competent, then you can apply to a judge, and a judge can determine whether the 5% is appropriate.
Okay.
It is taxable income to the executor.
Yeah, I was about to say that. Yes,
Because it's a job.
Yes.
Okay.
A T slip gets issued
Okay.
by the estate for the income.
And if there's multiple executors, you split the 5%.
Didn't know that.
Yeah.
So what would be some of the considerations for someone to have in choosing an executor?
It's great if it's someone who is familiar with the estate administration process. If it's someone who's been through it before, or someone, maybe your friend is a lawyer like me, who this is what I do for a living.
Mm-hmm.
Those are great things. But more than that, if you don't have someone in your life like that, it's great to choose someone who is good at getting stuff done.
Mm-hmm.
They don't necessarily need to know a lot about finances. They don't need to know a lot about tax. They just need to be able to get stuff done, because a lot of times what holds up estates is waffling,
Waiting on information.
not making decisions efficiently, not getting stuff done, and not talking to the right people. Because most of it you can go through professionals for guidance or help, but you have to know who to ask and what to ask.
Right. So it sounds like someone in that role should be pretty organized too, right?
Yeah.
Yeah. Just to be able to kind of juggle all of those things and all those people.
Yeah. Yeah, absolutely.
I used to work at a financial institution, and our head of tax and estate used to joke that if there's someone in your family that you don't like very much, you name them your executor.
Absolutely.
Right? Just because it can be arduous and stressful.
Grind, yeah.
Somehow I've ended up the default for so many people, and I'm like, no, thank you.
Yeah, fair enough.
I mean, obviously, if they ask me politely, I have said yes, but it's not fun.
You can just charge the full 5%.
Yeah, for sure.
I think in talking about actionable steps, we've talked about a whole bunch of them already, but I'd like to just put out there that, the simple things, the simple controllables are very important. So this is naming beneficiaries on your accounts.
Yeah.
Right. There's an example that comes up all the time with tax-free savings accounts, where you can name a beneficiary or you can name what's called a successor holder. Right. So with a tax-free savings account, any Canadian 18 after 2009 has $102,000 worth of tax-free savings account room. So if there's a couple, each might have that amount in a tax-free savings account or more if it's grown. If one named the other as beneficiary and the other passed, they wouldn't be able to take that TFSA and fold it into theirs and keep it tax-free. But if they name their spouse as successor holder, then the spouse actually inherits the entire account, including all the TFSA room. So that's a really important thing, a little thing that can it could just be ticking the wrong box that decides whether or not that happens.
You have $204,000 of deposits,
right,
that are growing tax free that you can use towards sort of cash flow retirement planning. And
that's
stuff
a big
like
deal.
Yeah. And sorry.
No, go for it.
As I say, on the flip side, I sometimes have the opposite conversation of someone wants to name their child, but maybe their child has a disability and can't handle receiving that money outright. And I say, well, in that case, it's more appropriate to name the estate and not name a beneficiary, because within the will, we can do a trust, and someone else can be in charge of that money and doling it out to the child and ensuring that it's invested appropriately. So it's just so important to go in and make sure that there is a decision made, and that it's made with keeping in mind the considerations of your personal circumstances.
This is the first time we've mentioned trust in this recording, Could you elaborate a little bit on like what a trust is used for, or like a couple different examples of different types of trusts?
Yeah. I feel like a lot of people have heard about trusts,
Mhm.
but just to overly simplify it, a trust arrangement is where one person is holding money, or an entity is holding money for the benefit of someone else. It's the splitting of ownership between the legal title holder and the beneficial holder. So in that circumstance I just described, it would be a testamentary trust, which is a trust created within a will. And maybe you appoint your trustee as the deceased sibling, and the child of the deceased is the beneficiary, the person with the beneficial ownership.
Okay, there you go.
Yeah.
I think a question that maybe we get asked often, or people may consider, is like, when should I do this? Like, when should I engage a professional and start creating an estate plan? Like, is it when I'm at a certain asset threshold? Is it, like, what do you think? What do you think about the answer to that question?
Oh, there's no one time for everyone.
My go-to canned answer is like when other individuals are financially dependent on you.
Yeah, I'd say that's for most people when you cross that threshold of you care to control the uncertainties of if you die or become incapacitated.
Yeah, fair enough. So you perhaps you're just getting married. That might be a situation, a common situation where you might consider a will and power of attorney, right?
Absolutely. If you're just getting married, a lot of people...
Or just partnering. It doesn't have to be marriage, right?
Yeah, actually, even more important if you're just partnering up with no plans of getting married, because under a lot of provinces, common law relationships are not treated the same as a legal marital relationship.
Okay.
In Nova Scotia in particular, it's extremely important that if you're partnered up long term and you want each other to benefit from your estate, that you do have these documents in place, because otherwise your common law partner is treated no differently than any other person on the street.
Oh, wild.
Interesting.
Yeah.
So that might be a situation where it becomes important. Having children or caring for dependents might be another situation.
Absolutely.
Right? Yeah.
A lot of people come to me as they're having children, because that's when they really start to care. They say, my spouse will figure it out. They're a grown up. But once they decide to have children, that's when people really start to think about it. One thing that I do find holds people back, though, from coming in is they get into the discussion of, well, where did the kids go?
Right.
And that is a hard one.
Oh, for sure.
Yes.
Everyone wants them to go to their own parents or siblings.
Yeah.
Or opposite, they
don't want them to go to those parents. Yes. Yeah. Fair enough.
Yeah, truly. Yeah. It's something that's such a hard decision. And I do find it does hold people up a lot, which again, no decision is a decision.
Yeah.
Back to the theme. So I try and encourage people, like, it's just a decision for today, next year. You can update it in a year. You can update it in 2 years. Mm-hmm. It doesn't need to be a decision from now until your kids are 18 years old.
Yeah. And within the will, you can have options, right?
Yeah.
And contingencies, I suppose, as well, right?
Yeah, a common one is people will say, well, if it's in the short run, I want them to go to my parents. But my parents are getting older. So in the long run, I'd rather them go to my siblings. And so often we'll, parents first, siblings second, and the parents can say the word if when something happens, they feel they're too old to handle the job.
Mm-hmm.
No, that's good advice.
I worked with another advisor, Daryl, and he had a situation where a gentleman was on his deathbed. He had received a cancer diagnosis, and he had a significant amount of non-registered assets. And Daryl went in and talked to him on his deathbed and said, "I know you're saving this for your grandkids. How would you feel about having your grandkids come in one by one and telling them what you have for them and how they plan to use it?" And in doing so, you could get some joy out of this thing that you've been saving for decades and decades. And so that's what the man did. These grandchildren came in one by one. The story goes on, and Daryl stayed in touch with a couple of the grandkids, and one of them decided that they wanted to fix up the dilapidated family cottage. This man had maintained this cottage, and when he fell ill, it kind of got overgrown and they stopped going. And this one grandchild had really fond memories of the cottage. So he used the money to fix up the cottage. And, 10 years later, Daryl saw this grandchild and there was a picture, that he got to see. It was all the great grandchildren standing in front of the cottage. It was just really, really sweet,
That's
right?
so nice.
Yeah. But, and
that's so nice.
I guess the message there is with a little bit of planning and some confidence in your plan, you might not have to wait just to leave it behind. You can enjoy it while they're here.
Yes.
Right.
I really like that.
Yeah.
That can sort of lead into why it's so important to talk to professionals about this, because giving something like cash during life can be such a wonderful benefit to your kids because it gives them the choice for you on how to spend it and for you to see it.
Mm-hmm.
Often I'll have people come to me and say, hey, I want to gift my family cottage during life. And then I start talking to them about the tax consequences of that. And that can be just wicked. And I say, so where are you going to free up the cash to pay that on your income tax return next year? And unless you're on your deathbed, that is something you really, really need to consider. So there are so many ways you can gift during life, and talking about the potential tax consequences and what that will look like ahead of just willy-nilly doing it can be so important.
Yeah, a little bit of planning can go such a long way, right? And I think at the end of the day, this is where I'll tie in that quote from Keanu Reeves. But
I love it.
Nobody really knows what happens when we die. People have faith in what they think will happen, right? And this came to mind last night when I was thinking about doing this episode. But Keanu Reeves was on this Stephen Colbert show, and they were going through these questions, and I guess the topic of death came up, and Stephen Colbert just pointedly asked Keanu Reeves, he's like, well, what happens when we die, Keanu? And I don't know, he's kind of got like that surfer tone to him at all times, but he said something really profound. And he said, I know that the people that love me will miss me. And that was it, right? Yeah. It's just it's super sweet.
That is sweet.
But, you can just make things so much easier for those people with a well-crafted plan and putting some thought into it. Thank you for joining us today to talk about the art of dying. Amanda, thank you for being here.
Oh, happy to be here.
We would just encourage everybody to, at the very, bare minimum, to think through this topic and to consider your loved ones and who's going to be affected when you pass, so that you can take the necessary steps to pass things along in a thoughtful way.
Yeah.
You go ahead.
Sorry, I was going to say, it's a gift to your loved ones.
It is a gift to your loved ones. Yeah. Whether you come to Evangeline Wealth and Law, or you do it through your trusted advisor and attorney, we would just encourage you to do it.
Yeah.
Yeah.
Now you have a little bit of information to more confidently have those conversations.
The comments contained herein are a general discussion of certain issues intended as general information only and should not be relied upon as tax or legal advice. Please obtain independent professional advice in the context of your particular circumstances. This presentation was prepared by Matthew McGowan and Nathan England, CFP, for the benefit of Matthew McGowan and Nathan England, CFP, mutual fund representative with Evangeline Wealth Management, a registered trade name with Investia Financial Services, Inc., and does not necessarily reflect the opinion of Investia Financial Services, Inc. The information contained in this presentation comes from sources we believe reliable, but we cannot guarantee its accuracy or reliability. The opinions expressed are based on an analysis and interpretation dating from the date of publication and are subject to change without notice. Furthermore, they do not constitute an offer or solicitation to buy or sell any securities. Mutual funds are offered through Investia Financial Services, Incorporated. Commissions, trailing commissions, management fees, and expenses all may be associated with mutual fund investments. Please read the fund fact sheet or prospectus before investing. Mutual funds are not guaranteed, their values change frequently, and past performance may not be repeated.